I'll now cover in more detail the individual rights of appeal which will come under the national trial. The first right of appeal that the tribunal can consider under the national trial is the decision by a local authority to refuse to issue an EHC plan. This, of course, will be a decision made once they have carried out a full EHC needs assessment. In deciding whether to issue an EHC plan, the local authority and the tribunal on appeal will be applying the Children and Families Act 2014, section 37(1), and deciding is it necessary to secure that an EHC plan is prepared for the child or young person. The possible issues that we saw during the recommendations pilot and which we're expecting to look at in these type of appeals are where there has been a failure to obtain certain health evidence during the EHC process, where the evidence wasn't taken into consideration when the local authority made the decision. And the same with social care evidence. Was it actually not obtained during the EHC assessment process, or was it actually not even taken into consideration when the local authority made their decision not to issue an EHC plan? The second type of appeal that will come before us under the national trial are appeals involving the contents of an EHC plan. Now, they may arise once the plan is first issued following an EHC assessment. It can be an appeal following an annual review of an EHC plan, or in the case where a local authority has decided to cease to maintain the plan, and we at the tribunal have decided that actually a plan needs to be maintained, we can consider a contents appeal, i.e. of an appeal against sections B, F and I of a plan, and they can also be included under the national trial. The Code of Practice says that an EHC plan should be clear, concise, understandable and accessible to parents, children, young people, providers and practitioners, and that they should be written so as they can be understood by professionals in any local authority. I think there's 2 points that need to be made coming out of this particular bullet point from the Code of Practice. And one is that plans should be concise. And we have evidence at the tribunal that some of the plans that are being issued currently are not concise, and they are going over many, many pages, sometimes as much as 70 pages. So that will be an issue that the tribunal will consider when they're making decisions under the national trial, as they would do in other SEN appeals. The last point is also about the plans being written in a way that can be understood by professionals. And whilst some local authorities may use a banding or a matrix process as part of their policy making decisions to distribute resources, this shouldn't be reflected in the plan alone. If, for instance, it says section B funding or section C funding and then refers to a matrix, that should be fully explained and specified. So the different sections of the plan that we have are set out in the following slides, with specifically whether there is a right of appeal to the tribunal or whether it comes under the national trial. And I think this may be useful just to clarify exactly what the tribunal can and cannot do under the national trial. So section A of a plan should record the parent, child, young person's view. There's no right of appeal to the tribunal on this section of the plan, and it won't be covered under the national trial. Section B of the plan should specify special educational needs. There's a clear right of appeal against this section of the plan to the tribunal, and that won't be affected by the national trial. We will decide all issues in section B, as well as any of the other educational issues, before we consider any issues around sections concerning social care and or health. Section C of the plan should specify health needs. There's a national trial power to make a recommendation in this section of the plan, so any issues relating to the health needs of a child can be brought to us under those type of appeals. Section D is around social care needs. Again, there's a national trial power to make a recommendation, and it should be noted that this section of the plan should specify social care needs which relate to the child or young person's SEN and which require provision, not just under the Chronically Sick and Disabled Persons Act, but any other social care provision. If there is a need for other social care provision that's not linked to the SEN of the child, such as the child has a child protection plan, then that should not necessarily be referred to in the EHC plan. Each local authority in making their decision, and likewise the tribunal in making our decision, will have to be very aware of what that additional social care need is and look at the evidence around it as to what is appropriate to be specified in a plan. Section E of a EHC plan covers outcomes. These are the outcomes that are expected if the provision made in the plan, whether it's in social care, health, as well as education, is put into place. There's no right of appeal against Section E of a plan, and it's not covered under the national trial. However, case law has established that actually if the tribunal make a decision to amend Sections B and F of an EHC plan, i.e. Special educational needs or special educational provision of an EHC plan, that we can then, as a consequence, review the outcomes. Section F, special educational provision, is something that's ordinarily covered under a right of appeal to the tribunal. And again, this won't be affected by the national trial. It'll be part of the initial making decision process and will be covered under our ordinary rights of appeal. Again, I want to emphasise here the importance of Section 21.5, and this is the section that was developed based on previous case law, especially around the role of provisions such as speech and language therapy, OT and physio, which have been established through case law as ordinarily to be included in Section F, special educational provision sections of plan. Again, the evidence in a particular child or young person's case will be always considered when making decisions under 21.5, and we are expecting that there will be other issues that will be brought to us and argued that provision is to be special educational provision as opposed to healthcare provision and or social care provision. However, these will very much turn on the facts of the individual case before us. Section G of the plan will be health provision, and this will come under the national trial, and we'll have a power to make a recommendation on these issues. Again, it must be based on the evidence presented to us. The type of issues that we think that will come before us is specifications such as medical treatment, delivery of medication, nursing support, and on occasions also equipment. Section H will look at social care provision. This is split into two sections. H1 looks at the provision required for children as identified through any social care assessments that have been carried out. And H2 is any other social care provision. So social care provision made under the Care Act or any other provision that may not be linked directly to the learning difficulty or disability of the child or young person. Section I, educational placement, is part of the ordinary rights of appeal that will be triggered to the tribunal, and it must be emphasised in such cases we will be applying education law first and foremost in the appeal to make a decision based on the educational evidence, and then once that decision has been made, if we are then required to go and look at any social care and or health issues that are being raised under the national trial, we would then proceed on to make those decisions, but secondary to the decision-making process under the education law that we have before us. Section J of the plan is around personal budgets, and there's no right of appeal to the tribunal on these, and they're not covered under the national trial. And likewise, Section K, which lists the advice and information gathered during the assessment process or after annual review, listed there, that isn't covered under either the appeal or the national trial. The possible issues that we see as being raised in relation to the contents of an EHC plan are those raised where evidence is not actually obtained, or if that evidence doesn't specify need, provision or outcome clearly. And likewise, that will be for health and or social care. Issues around whether an educational placement is required or whether it's social care provision, and we can see that arising specifically in cases concerning young people over compulsory school age, or where they're moving into further education, and the whole issue of 5-day per week packages of provision. The last right of appeal to be included under the national trial is the right of appeal against the decision of a local authority to cease to maintain an EHC plan. That's a decision that's made under Section 45 of the Children and Families Act 2014, and it's made when it's determined that it's no longer necessary for the plan to be maintained for that child or that young person. If that young person is aged over 18, there are additional requirements under 45.3 to be taken into consideration by the local authority concerning whether they have actually achieved the outcome specified in the plan. The possible issues that we foresee in relation to these appeals are decisions made without adequate social care evidence or without adequate health care evidence. The type of issues that were raised in the cease to maintain appeals, including the recommendation pilot, was where a decision was based on a young person no longer requiring education and there being no social care provision put into place or anything recommended by social care, and in circumstances also adequate healthcare provision.